Right, good morning, everybody. Hopefully you can all see and hear me just fine. We're going to get started with our presentation today. As you've probably seen from the slide that's up on the screen at the moment, we're going to be talking about a recent case where the court considered the issue of setting aside a notice of discontinuance and the impact that that may have in a variety of cases. So you'll note that my name's Sophie Walmsley. I'm one of the juniors in the personal injury team, and I'm joined by Oliver Manley, who's also a personal injury barrister. We're both going to be talking to you at various different points. And if you do have any questions, if you could save those for the end and then pop them into the chat box, and hopefully we'll get around to answering some of those. Without further ado, getting started into the meat and bones of the case that we're going to be talking about today. But before we do so, it's important to turn back to the basics of discontinuance. And of course, the primary point is that a claimant can discontinue all or part of his or her case at any time, and that's reflected in the wording of the CPR. There are circumstances where you may need to get permission from the court. So one of those examples is if there's already an interim injunction, or I think that's supposed to say if there has been an undertaking as opposed to an undertaken. Again, if there's circumstances where the claimant has been in receipt of an interim payment, there either must be consent from the defendant or the court will need to give permission for that. Again, if there's more than one claimant, then all the claimants must consent, or again, you may need to turn to the court for permission. And finally, in a case of multiple defendants, of course, you can discontinue against one, but continue against the others. That will entirely depend on the circumstances of each individual case. So moving on to a nice little animation before we get to the main point. So the case that we're going to be talking about today is called Excalibur, hence why there was a big photograph of a sword and a stone. It's Excalibur Keswick Groundworks Limited. It was a case that was heard in the Court of Appeal. The background to that case was that the claimant was a man who was injured following an accident at his workplace. And the matter proceeded all the way up until the point of trial. And it was at trial, at the day of court, that a major discrepancy was noticed between what the claimant's pleaded case was, as to how he says he sustained his injury, and what was ultimately said in his witness statement. The judge highlighted that to counsel at the outset, and counsel took time to consider the claimant's position, and at that stage the decision was made to discontinue the claim. Unfortunately, the matter didn't end there, and the defendants, who were very unhappy with this, decided to make an application to the court to set aside that notice of discontinuance, so in accordance with the procedure in Part 38. And what they invited the court to do was to strike out the claim. And the premise of their argument was that the claimant's conduct had obstructed the just disposal of the proceedings. And of course, as you'll see from the slide, what the defendant's ultimate aim here was to strip the claimant of his quox protection. And there was some criticism that was made by the judge in that case about the time for when the claimant discontinued, and they worded it as he discontinued at the 11th hour and 59th minute. And what the judge did at first instance was, rather than address the question primarily of whether the notice of discontinuance should be set aside, they proceeded on the basis that it would be. And the follow-on from that was the judge found that the conduct of the claimant in discontinuing at that stage, and indeed running the proceedings all the way to that point, was such that it obstructed the just disposal of the proceedings, and then operated on the assumption that therefore the claimant shouldn't have any quox protection. And so accordingly, it was set aside, and the claimant lost the benefit of quox. Now, the claimant was understandably infuriated by this position, and the appeal was first heard by His Honour Judge Friedman. And he again considered the two discrete questions. So the first is whether the notice of discontinuance should be set aside, and with reference in looking at that question, the claimant's conduct and whether it obstructed the just disposal of the proceedings. Now, when it came to that appeal, what His Honour Judge Friedman had considered was that the deviation, or the fact that there'd been such a substantial change in the claimant's account, was very far removed from the kind of conduct that one would ordinarily sort of see as obstructing the just disposal of proceedings. It's something that, of course, as you'll all experience from your own practices, does happen from time to time, and it isn't something that is necessarily without more particularly egregious. And so what His Honour Judge Friedman considered was that the district judge had erred in looking at the matter from the standpoint of whether the quox protection should be removed, because that was ultimately what the focus had been on. And he went on to set out that there was nothing about the way, nothing about the claimant's conduct, particularly in discontinuing at that stage, which would warrant what he labelled the exceptional course of setting aside a notice of discontinuance. So the conduct of the claimant was no more likely to obstruct the just disposal of the proceedings in the circumstances, which is quite an important matter, because as we'll talk about and touch on, the right to discontinue is that you can discontinue at any time. And it's quite helpful to now have this guidance from the court indicating that it does take something quite exceptional to warrant setting that aside. We'll come on to what those circumstances might be in due course, but it is particularly important to recognise that facts such as these, where you get to court and on the day of trial the claimant's account seems to be entirely different or materially different to that that's been pursued so far, is not in and of itself likely to constitute something that would obstruct the just disposal of the proceedings. So moving on, so at the Court of Appeal, they considered more broadly the rules under CPR Part 38 and also the protections that are afforded under CPR 44, and coupled with that, obviously, whether how claims can be struck out under CPR 3.4. And they've noted the breadth of the discretion that the court has when they seek to set aside a notice of discontinuance. I've included paragraph 38 of the judgment there, which basically says that there is a breadth of discretion afforded to the court, but and the key part here, a claimant can discontinue as of right, subject to limited exceptions. And again, quite helpfully, the judge was right to state that there needed to be powerful reasons why a notice of discontinuance would be set aside, and that abuse of court process or egregious conduct is required before the court will deprive the claimant his or her right to discontinue the claim. So ultimately, on considering those factors and considering the specific parts of CPR Part 38, so which gives the claimant's right to discontinue and the circumstances in which they can discontinue, they rejected the argument that there should be a different approach taken in claims involving personal injury where quox applies, which was ultimately what the defendant was advocating for in the Court of Appeal, by trying to say, well, yes, this is the normal standard in terms of discontinuance, but the court needs to adapt its approach because of the application of quox. And what the court ultimately stated is that would defeat the purpose of quox, which attempts to correct the financial imbalance between claimants and defendants in personal injury cases. And they emphasised that the course of conduct that was taken by the claimant was one that is taken by many litigants, and it's not something that of itself provides a powerful reason to set aside a notice of discontinuance. And again, I think it's important to highlight that the court has gone to some lengths to indicate the exceptional nature and the powerful circumstances that would need to be at play for a notice of discontinuance to be set aside. So the issue of the material inconsistency in that case didn't demonstrate a determination to pursue these proceedings with the object of preventing a fair trial. So that very fact that there was such a discrepancy did not in and of itself mean that the proceedings were therefore unfair or that there wouldn't have been a fair trial. And what ultimately the courts clocked onto was that what the defendant had sought to do but had failed to do was to remove the protection that was provided by Quox, almost by the back door. And I'll hand over to you, Ollie, now. Oh, apologies.
Yeah, thank you, Sophie. Yeah, I think that's the one. Yeah. Thank you, Sophie. Yeah, I think it's clear from the reading of this Excalibur case that what happened here is that the parties got preoccupied by the motivation of the claimant to suddenly discontinue on the day of a trial, and thought that because the purpose of that discontinuance was clearly to avoid the potential for Quox to be disapplied, that the defendants thought that that gave them an argument, a powerful argument, that that was conduct that was otherwise to obstruct the just disposal of the proceedings. And I think that that is essentially to put the cart before the horse, and that's exactly what Lady Justice Nicola Davis said. She said that this is a case where actually the court ought to have been looking first at whether or not there was a justification to set aside the notice of discontinuance, which, as Sophie says, is as a right, and then if that is established, then you look at whether or not you can strike out the case pursuant to 44.15. Of course, necessarily those two tests are very similar, but what is absolutely apparent is that when Lady Justice Davis was looking at it, because it's the exercise of a discretion that it may be set aside, that obviously imports the overriding objective to deal with cases justly, and then that pulled in the concept of whether or not the conduct was such that the claimant has specifically set out to disrupt that. And put shortly, the courts don't want to discourage people from taking a view, a sensible view, whether that's on the day of the trial or any other time, to discontinue their claims so as to save court time, and in particular in cases where there is a Quox protection. The fact of that Quox protection should be in no way related to the decision whether or not to disapply, to set aside basic discontinuance. And I think that really sort of bites at the heart of what was going on in this case, and the fact that the defendants, and I think it was, again, Lady Justice Davis just simply said, I do not accept the defendant's contention that a court is required to approach 38.4 differently in a personal injury claim to which Quox applies, and it would otherwise defeat the purpose of the Quox regime and correcting that financial imbalance between claimants and defendants. And I think that's critical here, and she took the time to go through the history of Quox, setting out why it had been brought in, and I think that really spelt out that perhaps the defendants in this case were approaching it from the wrong angle here. So I think that's interesting, because actually, as it turned out, the court saw it from completely the opposite view as the way the defendant was. It wasn't a question of the claimants seeking to file a notice or serve a notice of discontinuance to avoid Quox. It was a case of the defendant seeking to establish an abuse or a failure to obstruct just disposal of the proceedings in order to disapply Quox. So it was an interesting way that the court approached it in that sense. the point that I also wanted to raise, I think, was to do with the reference to the Arrow nominees case and Blackledge, because we're talking about whether what would amount to conduct that would otherwise obstruct the custodial proceedings within the meaning of the Excalibur case, and also referring to the Mab and English case, which is a cost case in 2018. And interestingly, the Arrow nominees case involved a case where the claimants had been forging documents, and it's interesting there because the reference to powerful reasons needed and also egregious conduct, I think really the fact that they then refer to the Arrow nominees case and forgery is the sort of thing you need to be looking at, as opposed to a claimant, as in this case, who I think again, it was summed up quite nicely by Lady Justice Davis, who said, all that happened here is following an intervention by a district judge, having received likelihood, claimant recognised inconsistencies as between his witness statement and the pleaded case, weighed up his prospect of success, and having done so, made the decision to discontinue. It's a course of conduct taken by many litigants and doesn't begin to provide the powerful reasons necessary. So I think that drives the point home there that, you know, Quox is a system that comes into play with a failed case. It's a failed personal injury case. So those are exactly the sort of cases where someone's thought on balance, actually looking at it, it's no good. Completely different ballgame if, of course, you've got an FD issue. The other point that occurred to me in this case is to do with the costs issue and the cost spin-off from this sort of situation. And I think the case that I would like to refer to, which isn't on the slides, I'm afraid, is this Faulkner and Secretary of State for Business, Energy and Industrial Strategy. It's a 2020 decision of the High Court. And I think it's probably a useful warning shot to any defendant that doesn't have enough to go down the FD route when it comes to this sort of situation, which I'm going to come on to shortly, but nonetheless wants to have a go at disapplying Quox and setting aside a notice of discontinuance. Because in that case, the claimant successfully resisted a set-aside application by the defendant, scored a costs order, and then the defendant turned around and said, well, hang on a minute, surely we should be allowed to offset our entitlement to costs following a filing of a notice of discontinuance against the costs order that was scored by the claimant in the later application. And the court said, no, you can't. You can't exercise the right to set off in Part 44.12. So I think that's, again, an important lesson that certainly defendants, solicitors need to be aware of. Moving on to the FD sort of question, perhaps more so. So I think we're probably now on to the one with the practice direction 44. Just looking at the time. This is a case where, interestingly, the defendants didn't go down the FD route. And when you look at the facts, it's perhaps slightly surprising, considering perhaps the willingness of defendants to run FD points in these types of cases. Because this is one where the medical records stated that he tripped over a pavement. There was another reference to him having fallen off a scaffolding, and then the pleaded case was that he'd fallen off a ladder that was tied onto some scaffolding with a piece of string. So particularly the reference to tripping over some pavement, it's one of those cases where I can well imagine that other defendants would have attempted to run FD, and in which case they would have been dealing with a very different situation, because in an FD case, as long as the defendant has sufficient evidence upon which to raise FD, you do have practice direction 44, paragraph 12.4, which specifically allows a court to not even engage with whether or not a notice of discontinuance needs to be set aside, but rather simply, as we all know from the Alpha Insurance and Roche case, may direct that those issues of fundamental dishonesty are determined at quite a separate trial. And I think that it creates the combination of the Excalibur case and the Roche case creates a situation where, is there any case where if you haven't got anything that amounts to FD, you're going to be successfully setting aside a notice of discontinuance, because you do need to show something more, some egregious conduct. And the reality is, I'm struggling to come up with any examples of egregious conduct which wouldn't also likely amount to an FD outcome. Because if you think about the Arrow nominees case, forging documents that were going to be used in the trial, well, you're going to be running an FD point in respect of forged documents, as opposed to saying, well, that's egregious conduct that can justify me setting aside the notice of discontinuance, and that's likely to be the better route in the majority of cases where you've got enough to set aside a notice of discontinuance. You're likely to have enough to run an FD point and have that determined at a trial instead. I can see, though, why the defence did it, because, of course, you don't then have to have a trial to establish FD on the balance of probabilities. You can just simply argue and say, well, it's a strikeout under the provisions of 44.15, and that wouldn't necessarily have to mean all of the rigmarole of going through an FD trial in a case that has already been discontinued. So I think that brings me to our overarching points, I think, which are sort of practice points that both me and Sophie have considered sort of are thrown up by the Excalibur case. And the first point we make there is the welcomed relief and clarity for claimants. I certainly think that is the main outcome here, that just how difficult it is to run this type of point, and that simply a claimant who discontinues very close to a trial or on the morning of a trial in order to avoid the potential findings of FD that might come out in a trial isn't necessarily going to be the answer to being able to have that notice set aside. Of course, in this case, they filed the written notice of discontinuance on the morning of the trial, presumably writing them out by hand, I imagine, counsel did, and as soon as that's served on the defendant, it takes effect. And the error of the judge here was not to realise that they had to first consider setting it aside first. But you're going to need more, and it's not just a question of a claimant suddenly thinking, "Oh, I'm going to lose my claim," and that's not going to be enough. The other point I thought I should flag up here is that when you're thinking about making this application under 38.4, not only are you going to want to think about it quite carefully and bear in mind the case where costs weren't, the right to set off wasn't exercised, so you will be running a cost risk as a defendant if you lose this application set aside. But also you've got to bear in mind you only get 28 days to make that. It didn't arise in Excalibur because it was the application to set aside was made immediately on the day of trial. But that's something that certainly needs to be taken into account. That's a fairly short timescale. I don't know whether, Sophie, you've got any other points that you wanted to draw out from this.
Yeah, I mean, I think it's really important to stand back and look at overall what Excalibur seeks to achieve, which is essentially a bit of a slap on the wrist for defendants that want to run these arguments where there's not any real evidence of an abuse of process or an not disposing the proceedings justly, and trying to sort of cast back to the quite high standard that applies or that is seeming to apply from the wording of the judgment, that it would be quite important to consider the risks to defendants in particular if they do want to make such an application. And as you've already indicated, Ollie, those risks are also cost risks, but also for claimants, a little bit of sort of bolstering of not being overly mindful that if you do make an application to discontinue, that there's going to be real grounds for setting that aside just because you've taken the decision to avoid perhaps a negative judgment or a negative finding. And it's quite clear that Excalibur has indicated that doing that, making a tactical decision after seeing the evidence or being alerted to issues in the evidence to avoid a negative decision, it is not something that would constitute an abuse of process. The only factor, again, which I think we've already touched on and you've mentioned before, Ollie, is, well, this is all well and good, but would Excalibur have turned out very differently had the defendant actually raised fundamental dishonesty in light of the key discrepancies between the accounts? And case law and the civil procedure rules more generally suggest that a different approach would be taken in those circumstances where FD is certainly at play. And we already know that the back door behind that is contained witin Practice Direction Part 44. And it's also important to consider, therefore, if you do have a claim where either you're for the claimant and you're considering setting aside, what extent there are issues of fundamental dishonesty, because you're not going to be blanket protected by Excalibur on that point.
Yeah, no, I agree. I think so. Interestingly, I think again, Lady Justice Davis says, doesn't she? Says at paragraph 40 of the decision, says it is of note the defendant has not alleged that the claimant was or might be fundamentally dishonest, and I think that's probably a little bit of a hint there that the obvious overlap between what's required to set aside a notice of discontinuance under the 38 rule, as compared to Practice Direction 44 paragraph 12.4 is going to be likely to overlap in a lot of cases. The difference being, I suppose, is that, as I said, you don't need those findings in order to try and have a go under the 38 route, as compared to 12.4, where you're going to really need to have quite a lot of evidence already on paper to get the FD argument off the ground. But certainly food for thought, I think. I don't know whether we have any questions from anybody. We've got a couple of minutes, so if anyone does want to either raise their hand and come on camera, or alternatively you can type them in the chat, we can keep a lookout for those. Yeah, I don't think so. I haven't seen any. I can't see it. Can you see any hands raised, Sophie? I don't think I can.
No hands and nothing in the chat, so hopefully any questions that you did have been answered. But all in all, I think it just stands to reason that it's quite an effective little case, particularly for claimants listers. But also there are various different factors to consider, thinking about quox and particularly on the defendant side, to what impact FD may ultimately have on that.
Yeah, absolutely. And if anyone does have any questions that then later occur to them, don't hesitate to email the clerks, and then they'll get. We do have one. Oh, where's it gone? That's funny.
I told me to read it out to you, Ollie.
Yes.
Natalie asks, what about hopeless cases on liability, where hopelessness has been raised by D and a drop Huns offer made but not accepted, and then the claim discontinued?
Yeah, I mean, I think the problem is with this is that it's so easy to look at a claimant's conduct and apply what the normal response to that would be of any seasoned litigator, where you'd be seeking to run the sorts of cost arguments you might run. But we're looking for more than that. That is, it would be a great costs argument if you had a costs regime that wasn't protected by quox here, and I think it's about coming to terms with that public policy decision of a quox, of the reality of quox, and the purpose that it's designed for is to right that inequality of arms, and those sorts of conduct points that are made. They've got to be egregious. You know, it's quite a high bar. Powerful reasons and egregious, and pulling in that strikeout test. You know, that's what was being discussed in Excalibur. They specifically make reference to the 3.4 strikeout test, which is amusing in a way because they are slightly conflating the points about the set aside under 38 and criticising the judge for not engaging with the may set aside under 38. But I suppose the end game was always then to apply the strikeout test that's also in Part 44 to disapply quox. But I think you can always run those points, but I'd be amazed following Excalibur, given the points made in the court by the Court of Appeal, that would still be enough for you to get off the ground. You do wonder though what is likely to amount to that, given the way that this case has been approached by the Court of Appeal, and that leads me saying back full circle really, which is that you'll come back to the same outcome, which is you're probably more likely to have a case which, if it does get through that threshold, it's also going to be satisfying the threshold under FD, because it's some sort of much more serious misconduct. I suppose there would be, I'm just trying to think of things that wouldn't necessarily get you off the ground in terms of an FD case, but might be seen as powerful reason as an egregious conduct. Whether or not it could be perhaps shown that you'd called lots of witnesses or filed lots of witness statements or something in support of a particular point, made a trial extremely long, and then it was shown that you never had any intention of ever calling them in the first place. It's sort of obstructing a just disposal in that sense. If it was shown to be deliberate, that could be considered as quite egregious. I'm just trying to think out the box really, but no, hopefully that answers your question, Natalie.
And just to sort of piggyback on that, and as Ollie said, the way that the court have gone about wording the sort of test here, for lack of a better word, about powerful reasons and egregious conduct, it does seem to take it outside the realms of the norms of litigation. So what we're used to is the swings and roundabouts, where some cases, merits become less promising over time. It's also quite hard to envisage those sorts of scenarios where, for example, if the case was so hopeless from the outset, why an application for summary judgment or strikeout hadn't been made previously. So it's quite difficult to envisage that kind of situation, but it seems that Excalibur would give some real salient arguments, particularly on the side of whether a notice of discontinuance should be set aside, to say, well, no, it shouldn't. But I agree with Ollie, you may still find yourself in an almighty battle on a cost and a conduct point, depending on the nature of how hopeless it had been and how evident it had been and from when.
I think that's a good point, Sophie, because again, it's raised in Excalibur that exact issue about, even if there was enough here to show that this was a case with no reasonable prospect of success, it would have been the route would have been to go down the summary judgment route, and if summary judgment had been granted in the defendant's favour, quox doesn't get disapplied, and I think that's what was sort of highlighted quite a lot in Excalibur. But I think unless there's any other immediate questions or quick ones, I think that probably draws us to the end. But as I said, do please contact us if you have any other questions. But otherwise, I hope that this morning has been useful. Thank you very much.